Hi friends, and welcome to the 7th class of Law of Torts. Today we are going to start a new topic, and that will be covered in subsequent classes also, and that is specific torts. Specific torts are those torts where the element of mental ability is also there. So if you see what are the types, what are the categories of specific tort, there are a lot many. One of them is negligence, then nuisance, then defamation, trespass, assault or battery, nervous shock, etc. etc. So we'll cover some of them, or majority of them we'll cover in the classes. So the topic for today is negligence. So what is negligence in terms of law of torts? Negligence is avoiding the duty of care. So if somebody omit his legal duty, then it is called that he has committed a negligence. Now there are three types, or basically first three elements we'll discuss about the negligence. The first element of negligence is legal duty to take care. There must be establishment of a legal duty which a person is required to take care. The second element is the breach of that duty. If the person commits a breach of that duty, that will be considered under the negligence. And the third is the damages. What the damages are there. So we'll take the first topic first, which is legal duty to take care. To understand the legal duty to take care, we will discuss one case from English jurisdiction, that is Donoghue versus Stevenson. I had referred this case in the previous lecture when I was discussing about the privity of contract also in relation to tort and liability in the tort. But we'll discuss it again to get hold of what negligence is. So the case of Donoghue versus Stevenson, it is a 1932 AC case from English law and English jurisdiction. The facts of the case are, there were two persons, a boy and a girl, and they gone to a restaurant and they asked for a drink. So when they were consuming the drink, the girl seen some snail in the drink. The bottle was opaque, but when they opened and the girl was consuming it, she found that there is a snail in it. She faints, and later the couple files a case. Now the restaurant owner against whom they filed the case, he referred the case to the manufacturer, as he said that he was not the producer of that bottle, and also the bottle was opaque, so he could not reasonably see what are the contents of that bottle and whether there is something inside. So he told, I am not responsible for that. When the case was referred to the manufacturer, he said that it's a matter of privity of contract, because his duty is only towards the restaurant owner and he has no complaints in this matter, and he's not responsible for the ultimate consumer. So this was a milestone case, because in that Lord Atkin, he made two important decisions. The first is that the manufacturer is liable to all levels of customer, irrespective of restaurant or the final consumer. He is liable to all levels of customer, and privity of contract does not hold here in the law of tort. That also is established in this. And also the court established that when product can't be inspected because the bottle was opaque, so there cannot be a reasonable inspection, then in that case also the responsibility goes to the manufacturer, that he is liable for not complying with his legal duty. So this case is being referred here to understand what legal duty is and how the negligence affects the provisions of law. Now there are further subcategories to understand the legal duty to take care. In the subparts we will see, we will determine some facts. The first fact which we will review in view of case laws is, duty to take care depends on the reasonable foreseeability. Duty to take care depends on reasonable foreseeability. This we will review in view of case law. And the second fact here is that there exists no liability when injury is not foreseeable. So if the injury is reasonably unforeseeable, there is no liability in such cases. And then we will see a couple of examples or case laws from the duty of counsels toward their client or duty of doctors toward their patients or clients. So with these three factors, we will inspect the element of legal duty to take care. So the first one is, duty to take care depends on reasonable foreseeability. And in that, the first case which we are going to discuss is from Indian jurisdiction. It is Rural Transport Service versus Bezulam BB. It was 1980 case. So in that case, the facts are that the bus conductor, there was a bus and there was a conductor. The bus was full with the passengers. and he asked some of the passengers to sit on the roof of the bus. So the victim, she also sat over the top of the bus, and she died due to injury when the bus was traveling and it got hit with some bridge. So the bus driver was held liable in that case because of the negligence he created. Although this is a different matter because it is 1980 case. Today, if this case would have been came, the contributory negligence would have also been applied in this case. But at that time, the decision was so. Another case is Sushma Mitra versus MP State Road Transport Corporation. It is 1974 case from Indian jurisdiction. In that case, there was an injury in the ankle of Sushma Mitra when she was traveling in a bus and the bus was passing through the highway. So no enough clearance was there with another bus, and the driver of the opposite bus or opposite lorry, he could not take the proper clearance and he hit her ankle. So in that case also she got the relief because of the negligence and the legal duty to take care which the driver of the other lorry would have taken. A milestone case from Indian jurisdiction which is called Ghantaghar case is also important to mention here, which is between Municipal Corporation of Delhi versus Subhagwati. It is Supreme Court case of 1966. In that case, a lady, Subhagwati, she got injured when the building of Ghantaghar, it was partly demolished and it injured her. So MCD was held liable in that case because of the negligence. A similar case with MCD was also seen, which is Municipal Corporation of Delhi versus Sushila Devi. In that case, the same thing happened, but in a different aspect. Instead of the Ghantaghar or a building, Sushila Devi got injured as a branch of the tree collapsed over her, and that collapsed tree, that particular tree was supposed to be maintained by Municipal Corporation of Delhi. It was the property of them. So MCD again held liable in this due to negligence. So in the shadow of all these facts and cases, we can see that negligence is very clearly can be clearly find out, and the person can be held liable for that. But there is another class of cases also where the liability is tough to be ascertained, because in that cases there had been injuries but those were not foreseeable. So in that cases, in spite of the injuries, the person is not held liable because the reasonable foreseeability is not there. So in that case, the first case I would like to discuss is Katz versus Mogini brothers. It is 1917 case. The fact of the case is that a lady which has gone to a restaurant, all of a sudden a fan falls over her. So can we say the owner is liable? And there was no previous maintenance issue with the fan. It was a perfectly fine working fan, and all of a sudden it fell over the lady. Yes, you're right. There was no liability of the owner in that case. There is no liability because as the effect was not reasonably foreseen. Had it been a fault in the fan or something like that, then the owner would have been held liable. Another case, which is Glasgow Corporation versus Mayor. It is 1943 case. The fact of the case is that there was a big pot which a person was bringing. Some hot eatable was inside, and this is a matter of a picnic spot. So the person was bringing a big pot which was having hot eatable inside that, and he falls and injures, and the person got injured. So again, there is no liability which can be held on the owner or the person bringing the food because this sort of incident was not foreseeable. Now the third part of this element is the duty of counsels toward their client or duty of doctors toward their client. So I would like to refer a case from Indian jurisdiction which states or which held that doctors have the duty to work carefully with their client. The case is Jasveer Kaur versus State of Punjab. It's 1995 case. The fact of the case is that in a hospital, a newborn baby, all of a sudden it vanishes. And it was not there. So when it was searched that where the newly born baby has gone, then it was found that he's dead in the hospital. Actually, what happened? Some cat, he took the baby away and killed her, and he was found outside. So in that case, hospital was held liable for the negligence. So in this section, we have seen about the element of duty of taking care and the milestone cases, some of the very famous cases, and we have seen that we should ascertain first a duty, then only the breach of duty can be judged for. So the second element is the breach of the duty, which we just studied, that there exists some duty. Now for the breach of the duty, again there are some components. The very first fact related to the breach of duty is that the importance of the object to be attained is a matter of concern. In that case, there is a case which is Latimar versus AEC Limited. The fact of the case is there was an expected heavy rain, and because of that there was water logging in the surface of the floor in the factory, and there was a oil or water mixed solution on the ground. So what owner did, he sprayed the crushed wooden powder on the floor, and so that the slippage could be avoided. Now the appellant, the worker, he falls because of this. In spite of that measure, he falls and he got injuries. So what was the owner be declared liable? No, definitely not, because he took a reasonable care and that was justified. So he took the reasonable duty, he understand his duty and he took the reasonable care, but still after that the person has suffered the injury. So the owner cannot be held liable in such cases. Another fact with relation to breach of duty is that the magnitude of risk is important. Wherever the magnitude of risk is more, the duty to take care becomes more. So duty to take care depends on the level of or magnitude of the risk also. It is proportional. If the magnitude is more, the duty should be more. So we can understand this fact also with some cases. The case which I would like to refer is the Bolton versus State. Bolton versus State case facts are that there was a cricket club, and there was a ball which came out of the club and on the highway, and it injured somebody. Now defendant told that it would never happen in the past, since the stadium is made, that the ball could come outside, and hence there was no preventive measure taken. So here we can see that the standard of care was less because there was no probability or magnitude of the risk was less. So hence the liability was very less. It was not held. Similarly, opposite to this actually, there was another case which is Glasgow Corporation versus Taylor. It is also famous case because it is named as a cherry case also. So in this cherry case, what happened? There was planted a poisonous tree in a garden, and it was having fruits which resembles the cherry, but those were poisonous fruits. So a 7-year girl, she goes to the park and she sees those fruits and she confuses those with cherry. She eats them and she dies. So in that case, the corporation was held liable because the magnitude of the risk was more and hence their liability was more. The third important factor with related to the element of breach of duty is that the amount of consideration for which the services are taken, if that amount of consideration is more, duty of care will also be considered more, which means duty of taking care, it depends on amount of consideration also, and both are proportional. So the fact here can be seen with respect to 5-star case which we discussed in the previous lecture in the case of absolute liability. In the 5-star case, because the amount of consideration was more, hence the duty of the hotel, duty to take care, was supposed to be more. So these are the factors on this negligence can be analyzed. Now the third is the damages. For damages we have already taken up the discussion in the previous lectures. So damages, you are well aware how they can be analyzed. But the fact here is it was important to establish, for proving the negligence, first you have to establish that there exists a duty of taking care. If there is no existence of duty of care, then you cannot say that their negligence has happened. So once you establish that there is a duty to take care or there is a legal duty, then you have to analyze if because of negligence, is there any breach of that duty. If the breach happens, the negligence happens and the person is entitled for the compensation. So with this, I would like to close this lecture today, and the next session we will talk about the nervous shock, which is a very small topic. So we will quickly talk about it in the next session. Thank you. Take care. Bye.